Namaste, welcome to Courtroom. So let us start our preparation for Evidence Act for the purposes of our judiciary examinations. Open your bare act. Without that, these lectures will not work. And secondly, ये थोड़े से lengthy होने वाले हैं. These lectures, they are slightly lengthier than the short form lectures that we usually do. So, well, get ready please for impact. Evidence, the word is derived from evidentia, and this means to show clearly, to ascertain, to prove. Why is this detail important? Prelims का MCQ format. Evidence is derived from which word? Evidentia, which means to show clearly, to ascertain, to prove. Either of these options can be there, so you have to mark the correct one. तो कृपया करके notes भी अपने ऐसे ही organized करके रखिएगा. So thus evidence का जो main जो purpose है is to either prove or disprove the existence or non-existence of certain alleged facts. So अब होता क्या है, let us say कि कोई murder का case आया and let us say that Nandini is charged with murdering Aditya and Karan is the prosecution lawyer and he says that in that room in which this event occurred there was this remote and this remote was lying on the bed. कोर्ट कहेगा मतलब how is this relevant to our case? Because ऐसे तो बहुत सारे facts होंगे. So one of the purposes of the Evidence Act is to filter out the facts. So from the relevant facts to irrelevant facts. अगले lecture में हम काम करेंगे theory of relevancy पे. Because the court has limited judicial time. तो आपको, so the procedure is being regulated by the CRPC. I'll just come back by keeping this. So the court is going to be आपका regulated by the procedure. CRPC वाला सारा procedure है, but जो court के जो अंदर का जो procedure है of regulating evidence, that is being controlled by the Indian Evidence Act because we have limited time and not everything needs to be proved. फंडा clear है? क्योंकि हम एक बारी once we are through the core of the Evidence Act, उसके बाद we will specifically go कि question पे question बार बार क्या आ रहा है and then we'll basically become exam specific. But first we need to understand the core of the Evidence Act. So thus evidence का main purpose is to prove or disprove the existence or non-existence of certain alleged facts. अब ये allege नहीं होगा कि वहाँ पे remote पड़ा था बेड पे. It's pretty much irrelevant, but a blood-stained knife was found on the spot with somebody's fingerprints. Now the judge is interested. So the Evidence Act is written primarily by Stephens. That is the name of the guy who wrote it. और अभी मैं आपको नाम और वो स्टैटिक जीके का पोर्शन है एविडेंस एक्ट रिलेटेड वो सब मैं करा दूंगा आपको. उसके अंदर he has written it so that the judges save time and only focus on the relevant bits. ये relevant शब्द बहुत बारी repeat होने वाला है throughout the act. Almost 1/3 of the act, that is section 655, is dedicated towards relevancy of facts. तो उसी पे सारी लड़ाई. The party who claims the existence of a certain fact has an obligation to prove it, and party claiming non-existence has to disprove it or show that it does not exist. So presume again, Nandini says that Aditya was present in Vasant Vihar at 5 p.m. on Friday. She has claimed it. She has to prove it. So obviously now she has to produce some evidence, right? So her lawyer has to produce some evidence, a testimony by another witness. That can be one sort of evidence or one kind of evidence. And the party claiming non-existence, Aditya saying I wasn't there, that is pretty much a plea of alibi, has to disprove it. Ki, bhai, I was there in my college, you can check the attendance time sheet. So therefore that piece of evidence, the attendance time sheet, becomes relevant, not what Aditya was wearing on Friday 5 p.m. ki ji ye peele rang ki t-shirt mein khada. Who cares? Obviously not in this case. In some other case we may just care, but not in this case. Or show that it does not exist. So evidence is a means of satisfying the court or the truth in a judicial proceeding. Remember judicial proceeding? कहाँ पे? CRPC. Connect it. Start connecting the laws. So evidence, basically जो common parlance is not evidence in the eyes of law. हर चीज हम evidence screenshot ले लो, ये मैंने आपका video record कर दिया है, screen recording. Maybe they are just not admissible in a court of law. So the Evidence Act also regulates what enters into a court of law. Alright, so by checking its the evidence's admissibility. कि एविडेंस तो ठीक है, आप बहुत बढ़िया लाए हैं, लेकिन कोर्ट में एडमिसिबल ही नहीं है, अलाउड ही नहीं है by the Indian Evidence Act. So all of that we have to study. And why does this act then become so important at our judiciary preparation stage? Because you are aiming to become a magistrate. So your court, because you'll be sitting in a court and basically ruling a court, overruling a court rather, and overlooking a court and ruling that court specifically, that will be regulated by the Indian Evidence Act of what comes into the court as evidence. So therefore you as the king of the court or master of the court need to understand this act very thoroughly in and out. The master of this act in our Indian legal system was Ram Jethmalani. खैर अब तो वो नहीं है, but अगर उनका कोई lecture मिले आपको YouTube वगैरह पे on evidence act, do try to watch it after you are through with these lectures. All right. So evidence in common parlance is not evidence in the eyes of the law. So these are all pointers. जब आप philosophical कोई अगर आंसर अगर मेंस में लिखना चाहें तो अपने नोट्स में जरूर डाल दीजिएगा, जो जो याद आए वो डाल दीजिएगा. अब क्वेश्चन आंसर हम बाद में डिस्कस करेंगे. Author is Sir James Stephen and his purpose was to division. इन्होंने क्या करा? He divided laws into, वैसे usually not he but generally we divide laws into substantive laws and procedural laws. Substantive law defines right, duties and liabilities. रेप क्या है, मर्डर क्या है, किडनैपिंग क्या है, क्या आपका क्या क्या काम है. Substantive law. Procedural laws are by which substantive law is applied. Therefore, law of evidence is a part of which the substantive the procedural laws with a view to ascertain liabilities and duties of the individual and of in particular the cases. यहाँ पे जो आपके जो सारे जो काम हो रहे, we are primarily, this is a procedural law. So this regulates the procedure of a court, right? So now what is the purpose of the Evidence Act? In formal language, what facts may and what may not be proved. Like remote wala, it need not be proved, क्या करना है, right? What facts may have to be proved कि भी वो वहाँ था ऐसे. What sort of evidence must be given of a fact which may be proved. So firstly we'll decide, we'll classify facts. अब कोई facts क्या क्या होते हैं अभी जरा आते हैं. Like for example, I am wearing a blue colored jacket. It's a fact. You are watching this lecture. This is a fact. Now then we have to subdivide facts into physical facts, psychological facts. बहुत सारे फंडे हैं, अभी धीरे धीरे करके we'll just open everything. What sort of evidence must be given of a fact which may be proved? Okay. By whom and in what manner the evidence must be produced by which any fact is proved. Evidence law or law of the evidence answers admissibility, like I've told you. What happens if party fails to adduce any evidence? Role of judge in evaluation of the evidence. The judge's discretion, either you accept that evidence, that you allow it to enter your court, or you allow it to be rejected. Of what matters, basically, witnesses can speak on of what matters witnesses can speak, on whom does the burden of proof lie, how is basically आपका ये जो सारा जो काम है कि how strong is the evidence, how will it be tested by the opposite party, by cross examination, examination in chief, etc. तो evidence जो आप सामने वाला भी लेकर आ रहा है उसकी भी तो scrutiny करनी पड़ेगी. All of this is under the Indian Evidence Act. So all such rules are there in the Indian Evidence Act. Are such rules necessary? Now we contemplate कि भाई क्यों है ऐसा. So the view is that the court ideal, basically आपका एक view इसके ऊपर है कि court should hear everyone who can say anything about that matter. But the second view is that in absence of laws, rules, this will hamper the administration of justice and the court from deciding the matter at hand, because too much judge discretion in deciding what is relevant and what is irrelevant will be there in the absence of any rules and laws. So for पहला view क्या कह रहा है? That the court should hear everyone who can say anything about that matter. कि सबको सुनो सारे मतलब to provide, let us say, the most amount of justice, the ideal form of justice. But that is a very utopian state. तो rules and laws, second view क्या कह रहा है कि जी अगर rules और laws नहीं हुए तो फिर judge साहब will have too much discretion, right? So that's from the point of view of time and certainty. The rules are necessary, and all of these rules basically under sections of rules, CPC वाले rules में चले जाएगा. Sections are given in the Evidence Act. So law of evidence is lex fori, that is law of the forum or of the court. Foreigners cannot insist on their laws of evidence being followed in our courts. So therefore this is lex fori. LLB entrance के time पे आप lex fori रट कर गए थे, याद आ गया? So this is lex fori, law of the forum. तो यहाँ पे कोई बाहर वाले भैया नहीं कह सकते कि he will basically, since he's a foreigner, so therefore he'll have to follow, the courts will have to follow a separate standard of evidence. No, we will follow our own rules given to us primarily by the British, right? So section 3 खोल लीजिए जरा बैराक में. Come to interpretation clause and court. Court includes all judges and magistrates and all persons except arbitrators legally authorized to take evidence, except arbitrators. All right. So once you open section 1, you will see that the act does not apply to arbitration proceedings. So arbitration में the Evidence Act is followed in letter and spirit, but not by the text of the statute, not strictly कि जी section में ये लिखा है वो लिखा है, because arbitration is a far less formal proceeding than an actual judicial proceeding in a court of law. So except arbitrators legally authorized to take evidence and all persons legally authorized to take evidence. CRPC से थोड़ा याद आ रहा होगा कि ये डिस्कशन हमने वहाँ भी करी थी. But code includes all judges and magistrates. MCQ. So breakdown, ideally speaking, keep two notebooks, one separately for prelims, one for mains. ठीक है जी. और अभी ये fact पे अभी सब पे आ रहे हैं. I'm just going to show it to you in steps. So law of evidence is same in civil and criminal proceedings. So this act applies both to civil and criminal proceedings. CRPC criminal, CPC civil, evidence दोनों जगह चलेगा. Basically evidence will act, you can say it is almost like the connecting bridge in between. तो उसके बाद ये होगा कि जी मतलब ये बहुत काम की चीज है क्योंकि सिविल और क्रिमिनल दोनों में आ रही, तो इसलिए मोस्ट यूज्ड एक्ट, वाइडली यूज्ड एक्ट. फॉर एग्जाम्पल डेथ के केस में क्या होगा, अगर सिविल केस बना कि नॉर्मल डेथ हुई और अगर उस पर विल या ऑपरेशन ऑन डेथ या विल डिस्प्यूट हो गई, सो दैट इज प्राइमरली सिविल केस, लेकिन डेथ से रिलेटेड है, राइट. क्रिमिनल में मर्डर सुसाइड हो गया, देन फिर उसका एविडेंस आप कैसे लेकर आएंगे, regulated, again that evidence is regulated by the Evidence Act. Law of evidence is same in both the cases. Evidence Act applies. यहाँ पे मामला दूसरा है तो दूसरे प्रकार का एविडेंस आएगा, but it will be regulated by the Evidence Act. और यहाँ पे भी वैसे ही कुछ होगा. However, section 24 to 30 confessions, they are exclusive for criminal proceedings. 53 to 54 character of accused persons, section 53A and 155 rape cases and applies to prosecutrix. तो 24 to 30 are exclusively for criminal. जब 24 to 30 का टाइम आएगा तब हम डिस्कस कर लेंगे, लेकिन आप ये काम कर सकते हैं that you can pause the lecture here, go to 24 and 30 and check them out, because I'm sure that you have done or basically heard of them in your semester examinations या semester का जब आपने काम करा होगा या अभी आप करेंगे. 24 to 30 के ऊपर ऑब्वियसली 3-4 केस लॉस का आपने हमेशा आंसर लिखना होता है. हम लोग भी कोर्स में करेंगे, बट मैं अभी खुलवा नहीं रहा. अगर आपने देखा हुआ है पहले दैट यू आर वेल एक्वेंटेड टू 24 to 30, ग्रेट, गो हेड, जस्ट सी इट वंस. ठीक है, तो 24 to 30 का ये वाला काम आप करेंगे. Section 120 competency of spouse to act as witness of other spouse. Civil proceedings पे 52 and 55 character of parties plus section 115 to 117 estoppel exclusively to civil cases. ये जरूर लिख लीजिएगा because prelims में आ जाते हैं questions on in such manner. Now weight of evidence, civil के अंदर या weight या standard कर सकते हैं. civil के अंदर क्या है, preponderance of probabilities कि तराजू किसकी तरफ पल रहा आपका भारी हो रहा है, राइट. प्रीपॉन्डरेंस मींस चांसेस, प्रोबेबिलिटीज अ चांस, तो प्रीपॉन्डरेंस की जी किस साइड का चांस ज्यादा है सच होने का. तो सिविल में वी अप्लाई दैट इज द वेट ऑफ द एविडेंस, स्टैंडर्ड ऑफ एविडेंस. क्रिमिनल में यू हैव टू प्रूव beyond all reasonable doubt, as you must have heard time and again from your law college semesters as well, but professors as well. But beyond all reasonable doubt में कि कोई डाउट नहीं रहना चाहिए, मतलब चेन कहीं टूटनी चाहिए. द आर्ट ऑफ गुड एडवोकेसी इज टू इंड्यूस अ डाउट इन द जजेस माइंड. सो यू आर गोइंग टू बी प्रूविंग योर केस बियॉन्ड ऑल रीजनेबल डाउट यूजिंग, or rather regulated, all of this is regulated by the Indian Evidence Act. Okay, फिर आगे चलते हैं. So under our system, under our legal system, we start with the innocence of the accused, and we are presumption of innocence of the accused, we are presuming, and we are going to test the case as a reasonable or a just prudent man, because the Judge Saab was not there. Judge Saab Sahiba was not obviously present at मौके की घटना, मतलब घटने जब वारदात हुई है तो उस पे मौके पे obviously आप present तो नहीं होंगे. So you're going to be judging the case as a reasonable, just, prudent man. All right. So all of your decisions have to be reasonable. भाई reason out करना ही करना है, ये नहीं कि कुछ भी reason दे दिया. Case law time. Munshi Prasad versus State of Bihar 2002 classic case on circumstantial evidence. अभी circumstantial evidence वगैरह क्या है? So direct evidence होता है, circumstantial evidence होता है. अगले लेक्चर में मैं आपको इसकी डिटेल में लेकर जाऊंगा, बट ये लिख लीजिए मुंशी प्रसाद वर्सेस स्टेट ऑफ बिहार. अच्छा, और एक काम और करिएगा, एक सेपरेट लिस्ट बनाते चले जाइएगा केस लॉज की, ताकि हमारे केस लॉज सेग्रीगेटेड हो, सेक्शंस एक जगह पे सेग्रीगेटेड हो. मैं बता दूंगा कौन कौन से इंपॉर्टेंट रखने हैं आपने, सारे के सारे इंपॉर्टेंट सेक्शन एज इन वर्ड टू वर्ड नहीं रखना कुछ भी. दैट इज ह्यूमनली इम्पॉसिबल टू डू. So we are going to be breaking down each and every section as well, but आपने वो सब काम अपना करके रखना है जिसके अंदर ये आपकी जो चीज़ है कि केस लॉ की लिस्ट अलग पड़ी हो, इंपॉर्टेंट सेक्शंस की लिस्ट अलग पड़ी हो, बेयर एक्ट का फॉर्मेट मतलब बेयर एक्ट का जो स्ट्रक्चर है वो अलग पड़ा हो, ताकि हमारे मोस्ट क्वेश्चंस वी विल बी एबल टू टैकल फ्रॉम आवर प्रिपरेशन. So graver the charge, the higher standard of proof, because court should not get carried away by the heinous nature of crime and mere suspicion. So because if the charge बढ़ते चले जाएगा, let us say कि अब आपने offense कर दिया है जिसकी punishment death भी हो सकती है, तो फिर evidence भी उतना ही tight, उतना ही strict और उतना ही clear should be pointing to your guilt, just because it is a heinous crime and you know not because of mere suspicion, just because कि आपने बहुत कुछ गंदा किया है और पुलिस वाले आपको पकड़ के लाया, like in the निर्भया case, then too the evidence का standard has to be very high, because now we are prosecuting you for something. The charge is extremely high in nature against you. So basis on which rules of evidence are framed. No facts other than the ones having some connection with the matters in controversy should be looked in by the court. All facts having rational probative value. ये word to word लिखेगा और यही मुझे आंसर में mention कराना. All facts having rational probative value, that is, which help the court to come to a conclusion, are admissible except in certain exceptional cases. वही तो question है सारे, right? Such as confession of client to lawyer. तो सबसे पहला, no fact other than the ones having some connection with the matter in controversy should be looked into by the court, because court अगर उस दिन जी जिस दिन मर्डर हुआ था उस दिन काले बादल आए थे लेकिन बारिश नहीं हुई थी, not required. All facts having rational, they should make sense. Probative value की भाई कुछ तो, they should bring some value to the table which help in the administration of justice, or to bring the court to a decision, or bring out a decision from the court, that is, which help the court to come to a conclusion, are admissible except in certain circumstances. जैसे कि अब आपकी client lawyer communication, it is qualified, it is protected, it is not admissible in a court of law. नहीं तो कल को वकील ही आपका सारा सच उगल देगा, तो फिर फायदा क्या, फिर justice थोड़े ना हो रहा है यहाँ पर, right? So all of this is primarily regulated by the Indian Evidence Act. Indian Evidence Act is result of Act of 1872. It came into force on the 1st of September 1872. Again, standard MCQ question from judiciary prelims. Contains आपके law of evidence. Sir James Fitzjames Stephens was the author of the act. इनके classic commentary भी आती है, बड़ी महंगी है, महंगी in the sense obviously it has its weight in gold, तो स्टूडेंट के लिए महंगी बढ़ जाती है, लेकिन कभी पढ़ सकें आगे कभी ज़िंदगी में, मतलब as in let us say that once you are selected and all and then you want to read this commentary, it will bring you a far better understanding of the Evidence Act. Section 27, अच्छा सेक्शन 27 अभी हटाएं, यहाँ पे हमने कुछ नहीं करना. इंडियन एविडेंस एक्ट इज, अच्छा ये बेसिकली एविडेंस एक्ट का सेक्शन 27 भी चैलेंज हुआ था, बट आई डोंट थिंक दैट यू नो राइट नाउ इज द राइट स्टेज जिसके अंदर मैं आपको इस पर ले चलूँ. Indian Evidence Act is a complete code. However, Chapter 12 of the CRPC Special Rules of Evidence, Chapter 12 of CRPC, मार्क कर लीजिएगा, और क्या बोलते हैं आपको दिख जाएगा वहाँ पे कि कुछ rules of evidence are given in Chapter 12 as well. अच्छा, अब Section 1 खोल लीजिए of the Bear Act. This act may be called the Indian Evidence Act. It extends to the whole of India and applies to all judicial proceedings in or before any court. So all judicial proceedings again where evidence is taken as per CRPC section 2 के अंदर दे रखा, or before any court including courts martials. So court martials वाले जो जनता है वो भी यहाँ पे covered है, but not to affidavits. Affidavit की spelling हमेशा is always a standard MCQ. आजकल law entrances पे बहुत ज़्यादा पूछते हैं. Affidavit, EAFFIDAVITS, presented to any court or officer, nor to proceedings before an arbitrator. So the Indian Evidence Act does not apply to affidavits or arbitrators. It shall come into the force on first day of September 1872. So when did the Indian Evidence Act come into force? 1st of April 1st of September 1872, not 1st April. Judicial proceedings includes any proceeding in the course of which evidence is or may be legally taken on oath. कहाँ पे दे रखा था? 2I के अंदर, ठीक है? अच्छा. Any proceeding may be termed as a judicial proceeding when its object is to determine a legal relationship between a person or any other person or between a person and any other person. तो यहाँ पे आप काम कर रहे हैं. यहाँ पे object is to determine a legal relationship and where evidence is being taken. Therefore, provisions of Indian Evidence Act do not apply to. एक बार जरा यहाँ पे दोबारा करते हैं. Any proceeding may be termed as a judicial proceeding when its object is to determine a legal relationship between a person or any other person or between a person. I think मैंने यहाँ पे दोबारा चीज वही लिख दी. तो provision of Indian Evidence Act does not apply to internal inquiries, departmental inquiries, proceedings under the Income Tax Act 1961. Case law लिख लीजिए CIT versus Binoy Kumar Roy लिख लीजिए, साहस रॉय होगा. तो ये केस लॉ है. डिपार्टमेंटल इंक्वायरीज में यूओआई वर्सेस टीआर वर्मा. मुझे पता है कि कुछ याद नहीं रहने वाला, कोई बात नहीं, थोड़ी चीजें मैं एंड में याद कराऊंगा, बट अभी आप लिखते चले जाइए. इंटरनल इंक्वायरीज में फायरस्टोन टायर्स वर्सेस वर्कमैन. तो ये इन्होंने, इनके पास क्वेश्चन पूछे गए कोर्ट से, तो उन्होंने बता दिया कि एविडेंस एक्ट इनको नहीं अप्लाई करती. बट मोस्ट इंपॉर्टेंट, प्रोसीडिंग्स अंडर द इनकम टैक्स एक्ट 1961 आर एग्जाम्प्ट फ्रॉम द इंडियन एविडेंस एक्ट. ट्राइब्यूनल्स एंड कंटेम्प्ट ऑफ कोर्ट प्रोसीडिंग्स के अंदर भी नहीं इंडियन एविडेंस एक्ट अप्लाई करती. To which of the following there's the Indian Evidence Act does not apply or does apply? तो उसके अंदर फिर options, they can make very complicated options. Plus special legislations may also limit Indian Evidence Act, such as the Family Courts Act, right? Family Court के अंदर अब यहाँ पे चक्कर क्या है कि why do you think कि family court को छोड़ा गया होगा? Because family court, the very personal matters may, standard of evidence may just not be very tightly regulated. So whether or not same be otherwise relevant or admissible under the Indian Evidence Act. So a family court may receive as evidence any report, statement, document, information, or matter that may, in its opinion, assist it to deal effectively with a dispute, whether or not the same would be otherwise relevant or admissible under the Indian Evidence Act. So section 14 in the Family Courts Act, जब भी आंसर लिखें on the Indian Evidence Act as a ये जो intro वाले जो आंसर होते हैं, philosophical जो आंसर्स होते हैं, please do mention section 14 in the Family Courts Act 1984. एफिडेविट्स पे भी नहीं अप्लाई होते. सो एफिडेविट क्या है जी? शैल इंक्लूड एफर्मेशन एंड declaration. So General Clauses Act 1997 के अंदर दे रखा है. So an affidavit shall include affirmation, declaration in the case of persons by law allowed to affirm or declare instead of swearing. This is given in the General Clauses Act. We don't need to enter into any further details in this. Arbitration के अंदर फिर क्या follow होता है? Principles of natural justice. Great. So definition of evidence. I told you these lectures are going to be slightly lengthy. Definitions of evidence. So तीन तरीके के आप काम कर सकते हैं. So as equivalent to relevant, as equivalent to proof, or as equivalent to material on the basis of which the courts can come to a conclusion about the existence or non-existence of disputed fact in the Indian Evidence Act's sense. So evidence means and includes all statements. आपके बैराक के अंदर please come to this provision. All statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. Such statements are called oral evidence. So evidence, सबसे पहला तरीका या पहला type क्या हो गया? It is oral evidence. All documents including electronic records produced for the inspection of the court, such documents are called documentary evidence. ठीक है जी? Hopefully it is clear. तो evidence means and includes दो तरीके के evidence Indian Evidence Act ने काट दिए. एक कर दिया oral evidence और एक कर दिया documentary evidence. So now each kind of evidence that we study will fall in either of these categories. Okay, great. So proved, disproved अभी जरा बाद में करते हैं. अभी यहाँ पे हमने करने की जरूरत नहीं है. Proved, disproved पे बड़ी लंबी क्या बोलते हैं डिस्कशन अभी करेंगे. So this definition is exhaustive. हरदीप सिंह वर्सेस स्टेट ऑफ पंजाब 2014 के अंदर ये कहा गया था कि all evidence either is categorized into oral evidence or direct evidence. So statement of accused taken under 313 CRPC without administering oath is no evidence. This was said in Dehal Singh versus State of Himachal Pradesh 2010, that if you haven't administered oath under आपका जो statement जो आपने ली है 313 CRPC, there's no evidence, we won't admit it. Oral statement of witness without cross examination is no evidence. This was again, this is SMAFQAR अफकार, ये आपका मिर्जा बेग 1932 का केस है. And letters without affidavits are improperly admitted. Letters produced without affidavits are improperly admitted. This is Kalpanath Rai versus State in 1997. So evidence is dealt by Indian Evidence Act either explicitly or implicitly, though we have only two broad main categories, that are oral or documentary. वैसे evidence, best evidence, circumstantial evidence, corroborative evidence, direct evidence, derivative evidence, documentary evidence, hearsay evidence, indirect evidence, oral evidence, original evidence, primary evidence, real evidence, secondary evidence, substantive evidence, testimonial, all kinds of evidence. But मैं इनको भी अगर क्लासिफाई करने जाऊं मेन कैटेगरीज में, it is oral or documentary only. All right. So admissible, it should be either received by court unless there is a legal reason to reject the said evidence. Admissibility presupposes relevancy. So evidence, if, well, the basic question is that if it is being admitted, it has to be relevant, right? So it is presupposing relevancy. तो ये MCQ आपका वहाँ पे मैंने 3 बार देख चुका हूँ इस MCQ कि जी which of the following statements is true, उसके अंदर होता है admissibility presupposes relevancy. Yes, that is true. Fact should not be received in evidence unless they are relevant and unless they are admissible. So inadmissible are evidence, inadmissible when they offend public policy, when privileged from disclosure कीजिए तो आने नहीं था, they were protected, like वो जो आपके जो client-lawyer relationship वाले facts. But evidence is implicit in Indian Evidence Act. Only best available evidence should be allowed in court, so कि भी उनका भी time बचे and then they could come to the decision very easily. Section 60 to 64. वैसे भी 5 to 65 is all about relevancy. Section 313 CRPC, power to examine the accused, is this is a bloody critical section. 313 319 पे बहुत सारे DJS में सवाल आते हैं. 313 CRPC 319 CRPC आपने करने ही करना है. So oral evidence, also referred to as testimonial evidence, यहाँ पे आपका section 60 के अंदर the terminology of direct evidence is used. So oral evidence must be direct. So एक और type of evidence ले आए लेकिन ये लोग direct evidence, but main category अभी भी oral या documentary ले आए. So real evidence का second proviso is section 60 में, provided that if oral evidence refers to the existence or condition of any material thing other than a document, the court may require the production of such material thing for its inspection. So weapon is basically in an offense, जो weapon है. Example, hearsay evidence is not received as a relevant evidence. आपने कहीं सुनी जो बात है, that is not received in evidence in court. So oral evidence must in all cases whatever be direct, that is to say, अभी यहाँ पे I think section 60, I think I'll just stop here of not going into the depths of section 60 क्योंकि इसके ऊपर हमने बहुत ज़्यादा काम करना है. तो जब अभी आई एम जस्ट इंट्रोड्यूसिंग द ओवरऑल स्ट्रक्चर आपको, ताकि ये टर्मिनोलॉजी पता हो, ताकि हम आगे जब काम करें तो ये सब मुझे बार बार बताने की ज़रूरत नहीं पड़े. ठीक है. When evidence is given of a fact, an issue, or of a relevant fact, it is known as corroborative evidence. So it is corroborating or confirming what was being said in the main evidence. So when evidence is given of a fact, an issue, or a relevant fact, so basically वो आपके मेन मुद्दे पे नहीं है, all connected में, तो this is corroborative evidence. This is taken along with substantive evidence. It confirms or gives support. कहाँ पे दे रखा है इनकी बातचीत, कहाँ कर रही है? 156, 157, 158, 157 is a particularly important section in the Indian Evidence Act. For example, car accident report and police complaint is not substantive. Oral testimony is substantive. तो कार एक्सीडेंट में अगर जब रिपोर्ट हुई तो उसके अंदर जो वहाँ पे जो विटनेसेस जिन्होंने बताया कि ये कैसे गाड़ी ठुकी, तो उसमें सब्सटैंटिव एविडेंस है. अब डॉक्यूमेंट्री एविडेंस, डॉक्यूमेंट मीन्स एनी मैटर एक्सप्रेस्ड और डिस्क्राइब्ड अपॉन एनी सब्सटेंस, एनी मैटर, तो बहुत तरीके के मैटर हो गए, एंड एनी सब्सटेंस बाय मीन्स ऑफ लेटर, फिगर्स और मार्क्स, और बाय मोर देन वन ऑफ दीज मीन्स इंटेंडेड टू बी यूज्ड or which may be used for the purposes of recording that matter. Illustrations. A writing is a document. Words printed, lithographed, or photographed are documents. Photographs, screenshots, etc. A map or plan is a document. An inscription on a metal plate or stone is a document. पत्थर के ऊपर लिखी हुई चीज, वो जो लोग वो पत्थरों पे वो पेड़ों पे भी लिख जाते हैं, right? तो अगर आप ये definition देखें, this is the widest possible definition that you can think of. An inscription on metal plate stone is a document. A caricature is a document. For example, a tree on which a particular number is inscribed. आजकल वैसे भी लिख जाते हैं ना, वो numbers डाले हुए हैं दिल्ली में तो, कि so that you don't end up cutting the tree. That is a document. So 3 questions that come out from this document. So is the document genuine? What are the contents? Are the statements therein true? Right. So that is the issue of the document. Example: newspapers. Newspaper, let us say cricket match is played. It is no evidence. Who witnessed must come to court. जो क्रिकेट मैच देखकर, अब ऐसा ना न्यूज़पेपर रिपोर्ट की जी वहां पे जी कोटला में मैच हुआ था, no evidence. We need someone who was there, who actually witnessed the event. We cannot just rely merely on newspaper reports. However, they fall into the definition of a document. Of documentary evidence, chapter 5 में 61 पे proof of contents of document. The content of documents may be proved either by primary or by secondary evidence. Primary evidence के बारे में इन्होंने यहाँ पे बात करी हुई है. Just showing you secondary evidence, अभी हमने इन्हीं सब पे आना ही आना है. और बहुत सारी चीज़ें. Secondary evidence means and includes certified copies, जो कि आपको ये copies made from original by mechanical processes which in themselves ensure the accuracy of the copies, and copies compared with such copies made or compared with the original. All your photocopies are secondary evidence, counterparts of documents as against the parties who did not execute them. Photograph of an original is secondary evidence of its contents, though the two may have not been compared if it is proved that the thing photographed was original. तो यहाँ पे बड़ी सारी हमने complicated चीज़ें यहाँ पे हमने करनी है, just showing you कि ये सब है भैया एक्ट के अंदर और आपको यही सब पढ़ना है, right? Primary evidence means the document itself produced for the inspection of the court, where a document is executed in several parts. Each part is primary evidence of the document. So if you produce a copy of a will, secondary evidence, but if you produce the will itself, primary evidence, right? तो ऐसे फिर हमने डॉक्यूमेंट्स को भी सब कुछ हमने बेसिकली द इंडियन एविडेंस एक्ट के जो सारा अगर आप देखेंगे, सो ओरिजिनल इज प्राइमरी, बेस्ट एंड कॉपी इज सेकंड. तो बेस्ट एविडेंस देना था ना हमने, सो ओरिजिनल ले आएंगे तो ठीक बात है, कॉपी सेकेंडरी एविडेंस. लेकिन खैर, टू कंप्लीट माई सेंटेंस, इंडियन एविडेंस एक्ट जो है, इट इज प्राइमरली बाइफर्केटिंग एविडेंस so that our life becomes much easier. Okay. So electronic record as a document, again section 65B. This यहाँ पे आपको सर्टिफिकेट चाहिए होता है, ये नहीं कि आप सीधा स्क्रीन रिकॉर्डिंग अंदर अपने मोबाइल से उठाकर दे दें. You need for it to comply with 65B. इसके ऊपर बहुत लंबी चौड़ी एक डिस्कशन है, एक हमने सैम्पल आंसर तैयार करना है 65B पे, राइट? आगे करेंगे. जस्ट इंट्रोड्यूसिंग इलेक्ट्रॉनिक रिकॉर्ड, दिस इज जस्ट एन इंट्रोडक्टरी लेक्चर राइट नाउ. Notwithstanding anything contained in this act, any information contained in an electronic record which is printed on a paper, stored, recorded, or copied in optical or magnetic media produced by a computer, herein referred to as the computer output, shall be deemed to be also a document if the conditions mentioned in this section are satisfied in relation to the information and computer in question. So that also all your screenshots, screen recording, sab kuch is a document under the definition of the Indian Evidence Act if everything in this section is complied with. We won't enter into the details at this stage. बाद में आते हैं इस पे घूमकर. Then ये पूरा का पूरा आपका सेक्शन है. I'm not entering into the details. डेटा के बारे में भी इन्होंने बात करी है, इलेक्ट्रॉनिक रिकॉर्ड के बारे में बात करी. इन्होंने बेसिकली सब कुछ बात करेंगे एंड ये सब बात करेंगे कि जी कौन सा एविडेंस, क्या पहली बात स्टैंडर्ड क्या है, वेदर दैट एविडेंस वो कौन सी कैटेगरी में आता है, वेदर इट इज एडमिसिबल, वेदर इट इज रेलेवेंट. सो इफेक्ट ऑफ 65B, इलेक्ट्रॉनिक रिकॉर्ड्स जो है डॉक्यूमेंट का स्टेटस देते हैं. सेकेंडरी इफेक्ट जो है आपको है, सेकेंडरी एविडेंस में 65B का जो नेचर है, सर्टिफिकेट इज मैंडेटरी. 65B4 का जो क्लासिक केस लॉ है वो अभी बस नाम लीजिए, अनवर PV वर्सेस PK बशीर 2014. दिस इज कार्डिनल केस लॉ ऑन 65B. इसको नहीं स्किप कर सकते इन आवर प्रिपरेशन. सेक्शन 62 प्राइमरी नेचर ऑफ एविडेंस के बारे में बात कर रहा है एंड ये यहाँ पे अभी नहीं काम करेंगे, 65B में बाद में करेंगे, सो दैट यू आर नॉट कंफ्यूज्ड. और आगे चलते हैं. वीडियो कॉन्फ्रेंसिंग को अगर रिकॉर्ड कर लूँ तो वेदर दैट विल बी एविडेंस, यस इट वाज अलाउड, ठीक है. और फैमिली कोर्ट के अंदर सेक्शन 10 प्रोसीजर जनरली जरा subsection 3 देखिएगा. Nothing in subsection 1 or subsection 2 shall prevent a family court from laying down its own procedure with a view to arrive at a settlement in respect of the subject matter of the suit or proceedings or at the truth of the facts alleged by the party and denied by the other. So audio series of call recordings. Topic है just introducing the stuff to you. Well, what does not constitute evidence? Affidavits are specifically excluded from being produced as evidence, but why? Because affidavits usually आप क्या होता है कि आप जाके affidavit बनवा लेते हैं, कोई भी notary sign भी कर देते हैं, primarily beliefs or hearsay. However, CPC 2002 amendment has permitted evidence in the form of affidavits. Case law है Utpal Das versus State of West Bengal. आपका FIR is not substantive evidence. FIR is corroborative evidence. So it cannot be used as the main evidence, but it can certainly corroborate the facts that will be there in the court. So now we go to proved, disproved, not proved. Proved. A fact is said to be proved when, after considering the matters before it, the court either believes it to exist. So if the court believes a fact to exist thanks to an evidence that you have, thanks to a piece of evidence that you have proved or rather produced, then it stands as proved. Now the cardinal condition is that the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. Disproved. A fact is said to be disproved when, after considering the matters before it, the court either believes that it does not exist or considers non-existence so probable that a prudent man ought, under the circumstances of a particular case, to act upon the supposition that it does not exist. Not proved. Proved, disproved, not proved. Not proved, a fact is said to be not proved when it is neither proved nor disproved. कि court confused हो गया कि यार मुझे लगता है ये हो भी सकता है, ये नहीं भी हो सकता. Then we are calling it as not proved. लेकिन कोर्ट को लग रहा है नहीं 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 ये तो नहीं हुआ होगा based on the evidence that you proved. Then the fact has been disproved. और अगर कोर्ट को लगता है ये पक्का हुआ होगा as a prudent man, then that piece of fact stands as proved. Simple funda है. Lecture 1 over, right? So hopefully ज़्यादा बोर नहीं हुए हो गया. I'll try to make these classes, even though they are online and pre-recorded, I'll try to make them as interactive and as non-dry as possible for you. We go to theory of relevancy in the next chapter or next lecture. तो ये हम काम करते हैं और यहाँ से हमारे सारे ये MCQ और ये मेंस वगैरह की सारी जो तैयारी है, फिर पहले हम ज़रा कोर्स स्ट्रक्चर समझ लें, फिर इस पे हम और काम करेंगे. ठीक है जी. नाउ आई विल सी यू इन द थ्योरी ऑफ रेलेवेंसी लेक्चर. टेक केयर.